Scott and I are the co-chairs of the Lee County Bar Association's General Civil Business and Litigation Practice section. Thank you very much for signing up for this seminar. We have some great panelists today, and I appreciate that you all have continued to come to our seminars. I told our panelists beforehand that every time that they have appeared, we've gotten tremendous feedback on the quality of the panelists, the quality of the commentary from the panelists, and how it has helped advance their personal practices. So I'm confident that we'll have the same commentary today. So let me tell you what we're trying to uncover. We're trying to get to the bottom of today. The topic is called remote litigation and ethics. And so what I first want to do is introduce our panelists, and then I'll go through the topic outline, and then we'll get started. So we're honored today to have 4 panelists. We have Judge Lee Frizzell Hayes. Judge Hayes, many of you will know, was on the county bench and then became appointed to the circuit bench in 2016. Before that, she was a senior staff attorney for the 20th Judicial Circuit. She's a member of 3 bars, Florida, Georgia, and the District of Columbia. I've appeared in front of her many times and have always appreciated her comments and rulings from the bench. We are also honored to have today Judge Tara Pallett. Many of you know Judge Pallett practiced for a number of years as a prosecutor, then as in-house counsel, and then opened her own firm. She's been on the county court bench since 2006. She reminded us just before we got on with all of you that she went to Notre Dame, and that Notre Dame is having an outstanding football season, and everyone else pretty much stopped talking about football after that.
Whew. I'm going to be quiet. I don't want to jinx anything.
Well said. We're also honored to have Robin Doyle. Robin Doyle has practiced for 30 years as a business trial lawyer and then opened an alternative dispute resolution practice in Southwest Florida. He handles exclusively mediations and arbitrations and has been doing so for many, many years. A number of you have used him and continue to return to him. If you haven't, he should be someone that's in your roster of neutrals. And we have a new panelist for me, and I hope he'll return after today. I told him he was in for a treat. John Miller, he and I were law partners for a number of years. He practices exclusively in civil litigation. He has a lot of experience in representing business, government entities, individuals, and insurance carriers. He's AV rated and has been recognized 7 times by Florida super lawyers as a rising star in civil litigation defense. Hey, John, aren't you getting a little old to be a rising star?
I think I officially aged out, yes, unfortunately.
Okay, great. So again, folks, thank you very much. We have a great panel today. So let's talk about our topic. So the first thing is we need to define what is remote litigation. And I propose, for purposes of our CLE today, and you're all getting credit for this, by the way, the LCBA will follow up with you and give you confirmation codes. But I propose that our remote litigation be defined as telephone and video conference. So you can appear in front of a judge, and we've been doing this for many years via telephone, either calling the judge's chambers or through court call. I remember when I started practicing in the late 90s, I saw in bankruptcy court, everyone would line up in front of a TV, yes, an old TV that was about 3 feet wide and 3 feet deep, and it was on a metal rolling carrier, and people would line up in front of that and appear in front of Judge Pasquet, and people practiced with the same decorum that they would have as if they were in person. So that was my first introduction to a form of video conferencing. Of course, all of us now, as a result of the COVID, unfortunately, we're all familiar with video conference platforms like the one we're using today. And I've talked to a number of lawyers and old-timer lawyers, self-professed old-timer lawyers, and they're convinced, we're convinced that a number of the changes we've seen in remote litigation are going to be here to stay once this COVID crisis ends, which hopefully will be soon. So But for purposes of today, we should consider remote litigation to be telephone and video. But I invite our panelists to, broaden or narrow that definition. Two of our panelists, of course, are judges. Another is a trial lawyer, and another one is a longtime neutral. Judge Hayes, do you feel that this remote litigation definition is a good working one for today?
From my point of view, it is.
Okay, all right. Judge Pallett?
Agreed.
Mr. Doyle?
I don't think there's any question that it is working well. We actually did the statistics this year, trying to review the outcome of mediations that were done by online dispute resolution versus the in-person, and the outcome is virtually the same. We settle the same percentage of cases online that we settle. In fact, during the first few months of the pandemic, I think our settlement ratio was much higher but overall for this year, we've settled as many cases by Zoom as we did in person.
Well, statistics make believers out of a lot of people. John Miller, what do you think? Do you think this is a useful definition, at least for today's purposes? Or would you add?
I do, Carlos. The only thing I might add is the remote submission of exhibits doesn't necessarily fall in the video or telephone strict definition, but there are issues that can arise with electronically submitting exhibits either to the court or to a neutral in a non-binding arbitration type setting. So I might add that as a component of your definition.
Okay, great. So we'll probably get to that when we get to the remote trial session, but that's a good reminder that we need to keep that in front of us. Okay, so then with our working definition of telephone and video conferencing, and keeping in mind the issues of electronic submission of exhibits, I want to go through 4 particular areas of litigation and identify the question, or answer the question, do we need new ethics rules, whether at the local level or as promulgated by the Florida Bar? So the 4 areas are going to be hearings, depositions, mediations, and trial. And so our panelists, each of them is going to have a different experience with a different aspect of that. And so we'll be able to go through that and investigate that today. Let's start with remote hearing ethics. So I'm going to screen share here. We're going to look first at the local rules. So rule Roman numeral 4K. I'm going to pull that up for us. I've highlighted, so 4K, trial conduct and courtroom decorum. If you look through this, it has 18 subparts, and I did look through it. There's nothing in here that discusses, to John Miller's point, the submission of exhibits at a virtual trial or hearing. Is there something that we need to do? Because this has become somewhat of a conundrum as we've been talking today. I've even gotten emails from opposing counsel. And I think there's several schools of thought. Traditionally at a hearing, most of the local judges have on their webpage, and if you haven't seen local judges' web pages, you better take a look at them. But they have their local rules. And most of them will have something along the lines of, anything that you want the court to review in advance of your hearing, you must send to me no later than 5 days or 7 days, something like that, before the date of the hearing. And some courts even have, the specific time by which it must be sent, which is very helpful, because then you can just kind of count it out on your calendar and write it down, and that's your deadline to get something over to the judge. In the remote hearing age, I think that's probably the same, but let's start with Judge Hayes. What do you think? Do we need to change the rule?
Usually with me, Brad Rosso, the longtime civil clerk, is emailing attorneys to tell them to send him all the exhibits, like you say, about 5 days before trial so he can mark them and have them marked. But I don't like to write on the official copy, so I'd like one too. So yes, it probably would be helpful to have that cleared up with a more, spell that rule out a little bit more.
Your Honor, would you have that for hearings as well, or just specifically for trials?
I think an evidentiary hearing or a trial. I don't think we need it for a, if we did it for a hearing, we'd really have to continue all the hearings, I think.
Lots of dead trees.
Yes.
Very good. Okay, Judge Pallett, what are your thoughts?
I agree. Certainly all judges can make their own determination what timeframes they like to look at. I do like the 5-day submission. Most of mine, though, they're submitting actually to the clerk's website there, and I have them identify Exhibit 1, Exhibit 2, etc., or however they want to name them. And as long as it's there within 5 days, there isn't an issue, of course, copying the other side. And that's both for my hearings and trials. And since we also do, it's even civil traffic court, our law enforcement officers are actually submitting their proof of radar and their certifications 5 days before to the website, and copies, and it's available to the defense attorneys to review before the hearings. So it really has a broad reach that you might not even think about, but I think it should be outlined a little bit more clearly. And certainly in looking at your highlighted portion, trial conduct and courtroom decorum, I don't know, are we going to have an opportunity to give some opinions on the general overall tone of, or do you just want to keep it right now towards the submission of exhibits?
Absolutely. You're the judge, Judge.
Well, no, just real quickly, in general, I think what's really is needed, and it's interesting, because people are sitting at their homes or sitting in their offices, many people literally are wearing t-shirts. Attorneys are wearing tank tops. Pajamas. I mean, attorneys, like, it's sad that we actually have to say dress as if you're in court. I've had individuals appear while driving, literally a zoom up, and they are driving. And I remove them from the meeting and tell them they can call back when they're pulled over safely. And so it's just things that you think you wouldn't have to say, but it's kind of odd. One thing that's very helpful for me is that when attorneys appear, they put ATTY and then their last name. So this way, once they show up, because like today I had 2 full screens of people, and attorneys would get lost, especially when they're not dressed properly and sitting in their bedroom. And I needed to see ATT last name to know that they are an attorney to call their case with, over 100 people. So those are just a couple little tidbits maybe to add somewhere.
Great. Those are great points. So Zoom does not mean you're driving. Zoom means you're.
Yeah. It's amazing. I mean, literally it's happened like 4 times. Just driving on the phone. And one without a seatbelt on too. That was also interesting.
Report
on a civil traffic citation case. But anyhow.
Thank you. And that's a great tip. By the way, I noticed that for the first time a lawyer did that. He put his name and then put, counsel for plaintiff. And I found that very helpful in a hearing. So I appreciate you making that solution. I had totally forgot about it until Your Honor just mentioned it now, and it's something I need to do. Mr. Doyle, any thoughts on, you practiced for 30 years. Any thoughts on whether, from a practitioner standpoint, we would need a new local ethics rule on virtual appearances at hearings?
Well, I certainly would agree with Judge Pallett regarding the physical appearance of people on screen. I've seen some of that in my mediations and arbitrations. It's been 15 years that I've been a neutral, so my experience is not recent with regard to appearing at hearings, except in arbitration hearings, in both the binding and non-binding arbitrations. And I think the same things would hold true for a court hearing. But in a non-binding arbitration, one of the problems that we have is attorneys don't treat them like they do an evidentiary hearing at the courthouse. If they're appearing in front of the judge, they call witnesses, they present documents, then they make their argument. Since they're allowed to proffer testimony, what often happens is what I hear is one very long argument. And it's very difficult to sort out what is a proffer of testimony and what is simply the argument of counsel. So I don't know about a rule or how we would address that. It's a practice matter, but I think that should be addressed with the bar.
Judges, are you listening? I think that's what Mr. Doyle was saying. And hopefully I'm not roping George Knott into a new job. Mr. Miller, thoughts from the front lines of the remote litigation?
Yes, Carlos, thank you. I had the unenviable position of going last, and so all of the low-hanging fruit has already been selected by the speakers that went before me. I had written down professional attire, submission of exhibits, and exchange of case law in advance of the hearing. So those were the three biggest issues that I saw with the conduct of a remote hearing, or that I've encountered. And I think those have all been addressed by the folks that went before me. So I don't necessarily have anything to add in this regard.
It sounds like attire is a universal issue then. Everyone has mentioned it. I'm making notes here for George to follow up on this bar project. Let's talk about the bar rules. So I'm going to pull up a different screen here. These are the rules of professional conduct. So this is chapter 4, and section 3 of chapter 4 is advocate. And so if you look at, I've highlighted 2 rules that potentially may apply here. And again, we're talking about remote hearings. So this is rule 4-3.4, fairness to opposing party and counsel. And I'll just rapidly scroll through them. They seem to me to be broad enough, and then we'll just go to the next one, rule 4-3.5, impartiality and decorum. They seem to be broad enough to cover all of the topics that, or all of the issues that have already come up, which is attire, submission of exhibits, and case law, basically, professional demeanor. These existing bar rules theoretically cover that. Your decorum is important no matter where you're practicing from, is what I think I'm hearing from everyone. Any additional comments, Judge Hayes, on the Florida bar rules as they address remote litigation ethics?
The biggest
hearings?
problem I have is ex parte when we're having telephone conversations. Sometimes it's that the one attorney can't get through. I'm using Court Scribes because it's free right now, and people complain when you make them use Court Call, which is fee driven, but Court Scribes is not necessarily always efficient. The other thing that happens is if one party talks a lot and somebody tries to interrupt, I can't hear the interrupting party because of the technology that only lets one person speak. So if one party is not on the line, because they can't get on court scribes or they forgot. Of course, I've had both of those happen. Sometimes I've lost an attorney because of the technology. I won't know if I've lost an attorney because I'm calling in on the phone. I understand that people on the computer can see when somebody has dropped off, but someone has to tell me if somebody else is not there. I'll find out who's present at the beginning of the hearing, but then that'll be the last time I'll know until I call on somebody and they don't speak back. I'm asking one attorney to go ahead and contact the other, and I'll go on to another case on my docket and come back and recall that case. And that seems to work pretty well. The opposing counsel has been very kind in trying to get that person on the phone. So I try not to have ex parte communications, but it's not always easy.
That sounds like a very appropriate practice, and I feel like I've seen courts do that when we had court in person. If someone was late, the judge would typically ask the attorney who appeared to go contact the other attorney and would move the hearing to the end of the docket.
Even when, of course, I expect courteous attorneys to do that, but even when they're attorneys who don't care for each other, they seem to be going out of their way though to include the other side, so it's not ex parte. I appreciate that.
Very good. That's good to hear about our bar. Judge Pallett, any further comments on the Florida bar rules that may apply to the remote litigation ethics for hearings?
Well, looking at more of the Zoom related, I think there is a tendency to make it easier for people to interrupt each other, because I think that the level of decorum is softened in Zoom, maybe because people are used to communicating with family members or friends or conversational. So I find that, and this is also dealing with a lot of pro se litigants, there's a lot more engaging rather than being patient until asked to comment or offer an opinion. So in that respect, I think that Zoom is actually, or video conferencing, it's making it, I have to remind them more to just wait, and they'll have an equal opportunity to be heard. As far as telephonically, I end up calling on the line the party, are you ready for your hearing? And they put it on, and then I call the next party. I actually call the parties because I'm not certain exactly when I'll be finished, and I want to make sure that I can get them on the line. I haven't really had any issues at all because it's all just ministerial contacting, getting the attorney on the line, asking them to wait. I have had an issue where a pro se litigant had hung up during the telephonic hearing, and I didn't know that they hung up, or they could have gotten disconnected and we went on with the hearing and I didn't really know. So that is a little bit challenging.
Very good points. Thank you, Judge Pallett. Mr. Doyle, any further thoughts?
No, I don't think so regarding the hearings.
Okay. John Miller.
Not anything specific other than, appearance, professional appearance, I think also goes to what's in the background of your Zoom screen. I've seen people show up with, funny backgrounds or, things that can be distracting in the background of their Zoom screen. And I would think that would not be something that you would want to do. But other than that, nothing to add.
Maybe just piggybacking on that, I will say that some of our counterparts on the other coast, whether it's good or bad, I'm not really offering that opinion, just the idea. They don't allow anyone except a judge to use a, what is it called? The screen behind.
Virtual background.
That, yes, the virtual background. They only allow judges to use virtual backgrounds. Everyone else has to not have one. So it's just an idea to throw out there.
And that's helpful for you to figure out when they're driving.
Yeah. True.
Let's move on to our next area then. So now we're talking about remote deposition ethics, and this again brings up the question that John Miller had brought up very early on: is what do you do with exhibits? So in typical days of yore, when we would have in-person depositions, I would give my deposition exhibits to the other lawyer when I handed them to his witness, and I never had any qualms about that being anything other than the highest professionalism, because I brought an extra copy for him. Things are slightly different now. We have remote depositions, and so I have gotten deposition exhibits the same day, but in advance of the hearing, or excuse me, in advance of the deposition. I understand some people have received them the day before, and some get them, when they show up on the screen share. So there is a local rule on this. I'm going to change back to our local rules. Let's see here. So if you take a look at local rule 4F, and I'll scroll right back to it, depositions. And I've highlighted a couple of things. There's nothing in here that addresses about the what one should do about the submission of exhibits. So I think that may be an area that is where some bright line may need to be made. And then, of course, the other issues are, which I've highlighted. When a question is pending, you're not supposed to give advice to your client, and you're not supposed to engage in any conduct during a deposition that would not be allowed in the presence of a judicial officer. I guess now that would include allowing you to show up in a t-shirt and pajamas, but other than that, it seems like we have some remote litigation issues. So I turn it over. Have either of the judges seen any of these issues peculiar to depositions turn up in front of them in hearings, like a motion to compel hearing or motion for protective order hearing?
No.
I haven't had any either. No, not yet.
So far, so good.
Yes.
I don't think this comes up too much in your field, I'm guessing, Robin.
I did have an attorney in a mediation tell me one time that they had been participating in a Zoom deposition, and they learned somehow that opposing counsel was coaching his witness quietly in the background. So I would, I mean, that's clearly inappropriate. There's already a rule on it, so I don't think you need a new rule, but it is something that perhaps we need reminders of.
How did they find out about it, if you don't mind me asking?
I think the attorney and the witness were in the same room, and apparently they either heard it or the witness turned to the attorney and said, "What?" or something to that effect. So,
John, what's happening on the front lines on this?
Yeah, I mean, I think probably the biggest thing is the attorney interaction with a client or a deponent off screen that the other party is not aware of, whether it's, coaching, passing documents, pointing out things in documents. I typically ask at the beginning of a deposition, if the witness and their attorney are together. And if they are, I ask that the computer or the video camera be moved so that I can see both parties. Usually that request is granted. I've never had anybody say no, I'm going to stay off screen.
I've got those signals.
What's that?
I'm going to stay off screen because I've got some signals I want to make.
Right, absolutely. No, but usually if you ask, they'll expand the view so that you can see everybody. So that does away with that usually. It just the mere technology involved with Zoom makes making objections difficult. If the attorney and the answering deponent are kind of going back and forth rapid fire, it can be difficult as the defending attorney to interpose objections, because as Judge Hayes said earlier, if somebody tries to interrupt or interject themselves, it can sometimes get lost in the shuffle of the Zoom technology. So I've found that sometimes making deposition objections can be difficult. We talked a little bit about, Carlos, about sharing exhibits with the other side. I've had attorneys that, they bring their exhibits to the deposition without sharing them ahead of time. They will flash up, part of the exhibit on the share screen, but not the entirety of the exhibit. And if it's a document that I haven't seen before, either because it hasn't been produced or what, I don't have the benefit like I would in a regular deposition of asking to review the entirety of the document or looking at the document as questions are being asked. And instead the document gets emailed to the court reporter after the fact. So I think the sharing of exhibits in advance of the deposition, or at least providing electronically the other side with a copy of the exhibit contemporaneous to its admission, it would be appropriate. And the last thing that I think, hasn't been a big issue, but maybe become an issue if and when we start to see things turn the corner on the coronavirus is, I tend to find that an in-person deposition, especially of some witnesses like plaintiffs, it is much more effective than a virtual deposition. I like to be face-to-face with the witness. I like to have that level of interaction. I like to be able to report back to my client on the individual nuances of kind of how the deponent acted in person. And a lot of that is lost when you take a virtual deposition. And I would anticipate that, there will be attorneys that purely as a strategic type maneuver would insist on a virtual deposition, even as we start to see the numbers of coronavirus cases decline and the need for doing things all virtually decline as well. And I would like to see some sort of a rule or standard put in place about, when an attorney or a party can demand that only a virtual deposition take place in lieu of an in-person, because I think there is a lot to gain from being in person with a deponent, if of course it's safe to do that.
That's a great point. And it seems particularly for depositions that involve a great number of documents that the in-person deposition provides a much better facility for the management of the deposition process for all parties. I've had expert depositions where the opposing counsel and I were friends, so it wasn't too much of an issue, but he really messed up the document share. And if it had been two lawyers that did not get along, you could easily have ended up providing a war story for Judge Pallett or Judge Hayes, I suppose, in the right instances. So that's a great point, John. When can a party obtain an in-person deposition once the COVID is passed? Let's change screens again, and I want to look at the rules of professional conduct that may potentially apply. So here, this is not going to apply. Potentially the ones that might apply would be, I suppose, 3.4, fairness to opposing party and counsel. Again, we're talking about remote litigation, ethics, and depositions. And so this, maybe with a very broad interpretation, deals with the provision of exhibits prior to deposition. Sub A says we shall not unlawfully obstruct another party's access to evidence or otherwise unlawfully alter, destroy, or conceal a document. Of course, no good lawyer is ever going to do anything like that. But in terms of, the gamesmanship that may go along with, when do I provide my documents? I think you could make a case for this. Now, again, these are not rules of practice. These are rules of professional conduct, and this is a bar grievance issue. So I would imagine that it would have to be a pretty serious case of surprise document sharing, if you will. For example, in John Miller's discussion about document share. So if someone were to show the document on the screen, certainly it seems like the defending lawyer could object to it if the defending lawyer hadn't received the entire copy. And the reason would be, look, you have a duty as a lawyer to not obstruct my access to these things. And I want to have an exact copy of what is going to be attached to this deposition. And I don't know what's going to be attached. You're showing one page, not questioning your ethics, but simply just for the best practices of all concerned. I need to know everything that's going to be attached to the deposition. And you haven't provided me everything. So I think it would have to be an egregious and an intentional case of that, but potentially it could become a bar grievance. The other rule that may apply, I think, would be dealing with respect for the rights of third persons. That's Rule 4-4.4. We'll scroll there. So if you have a non-party deponent, presumably, and one who's not, represented, again, how are you dealing with them in terms of providing exhibits? Again, in the pre-COVID, they get the exhibits at the same time as the question. In the post-COVID, maybe it doesn't matter since they're not represented and they're not a party. But this is a rule that you probably want to just take a look at. Respect for rights of third persons, same idea. Another rule you might want to just take a look at to familiarize yourself with it in this new context of remote depositions. Any other thoughts from any of the panelists before we move on?
Carlos, I would say that at least as it relates to this last rule, respect for rights of third persons, I think it's much easier to take a deposition now via video conference. And, I've had cases where we've sat through depositions of witnesses that almost certainly would not have been taken, but for the fact that it is easier and cheaper to do so by Zoom. And that kind of dovetails into the respect for the rights of third persons, only taking those depositions that, you believe are going to be material to your case, whether it's the prosecution of a case or defense of a case, and not taking needless depositions, purely for fishing type expeditions.
A great point.
And if I can add to, if counsel anticipates there might be an issue with documents being not disseminated before depositions, and you think that could be a problem, or anything of that nature, I certainly don't have any sort of issue with reaching out to my office. Judge, what's your position on how much in advance do we have to give the other side our documents if we're using them at a deposition, or what are your requirements? And usually I'll direct everyone to the website. But as far as deposition, I know there's probably nothing on my personal website about deposition. So definitely, I would definitely encourage any counsel out there, if you ever question, please do reach out and ask. We would rather not have the problem on the back end if we can make sure that everyone's on the same page from the start.
People have been setting status conferences and case management conferences too. And that works well. So we'll try to stop the problems before they arise.
Thank you, Your Honors. Those are great points. And certainly I know the bar appreciates having the ability to reach out beforehand before it becomes a problem. It's great advice. Let's move on. So this is remote mediation ethics. And I don't think this is going to have ended up in front of the judges too much. So I'm going to primarily focus the questions here with Robin and with John. We do have, let me screen share. I love screen share. Isn't this fun? Let's take a look. We'll go back to the local rules. And we've got 4 in number 3. Settlement and resolution. Attorneys are encouraged to utilize arbitration, mediation, or other forms of alternative dispute resolution if economically feasible. So against that background, Zoom certainly makes things more economically feasible for a lot of clients because they're not having to pay their lawyers to travel to another geographic location to attend a mediation. And it may make it easier for them because they don't have travel expenses as well. But other than that, the local rules really say nothing about that bears on remote mediation. Robin, this is your area. What do you think? Do we need some new rules for the era of Zoom?
The ethics requirements for a remote mediation are the same as they would be if you were in person. But I think they require a little bit different application. In the mediation, we know the decision maker has to be present. The mediation confidentiality applies, so the discussions are confidential. The parties have to be able to meaningfully participate. And then finally, the agreement itself has, whether it's partial or a complete settlement, it has to be in writing. And in fact, something that I noticed that a lot of attorneys miss is the requirement that mediated settlement agreements be signed not only by the parties, but by their counsel. That's clearly in the rule. But when you get to mediation, and you say, well, the decision maker has to be present, one of the problems that I see is the decision maker multitasking during the mediation, spending time really focusing on other projects at his or her computer and not actively participating in the mediation. It doesn't mean that you can't do other things at the same time, but there's some extremes there that I think cause problems. Another thing is in terms of participation, the confidentiality requires that everybody know who's participating in the mediation. And I'm concerned that on several occasions, I have learned after we started that there was somebody else in the room that was not identified, and we didn't realize until there was a conversation going on in the background that there was an unidentified participant in the mediation. So I have started making sure that we confirm with everyone that confidentiality means that every participant needs to be disclosed in the session. Another thing is recording. You can't record mediations. Now, when I'm running a mediation, I'm the host of the meeting. I can just turn off the recording in terms of the Zoom recording. But that doesn't mean that somebody's not trying to record it on their personal recording device. So I think it's important that we make that clear that recording is not allowed during a mediation. And then I ran into a problem just this past week that I had not had since the pandemic, and that was, we talk about meaningful participation in mediation. And we actually had to adjourn a mediation and reconvene at a later time when there was a qualified translator available. And so that's another thing. I mean, it really should be no different than an in-person, but it's another thing that I think we've learned that we have to check on in advance to make sure that everyone can meaningfully participate in the mediation. And part of that also is a technology question. You can't really meaningfully participate if your Zoom link keeps disconnecting. That can be caused by someone doing what Judge Pallett mentioned, trying to mediate while driving. It doesn't work very well. You lose connections and get disconnected. And because of security, you don't get back into the mediation without going through the waiting room. And so I have to go back and check and let them in. But if you have a very bad internet connection or not a good quality internet connection, it makes meaningful participation difficult. So that requires some advanced planning. And I would encourage attorneys to make sure that your clients have the necessary technology to be able to participate. And by the way, going to Starbucks and using the public Wi-Fi is not a good idea.
For a variety of reasons.
For a variety of reasons, right. And then the last thing that I have experienced, I think, which actually is very good in remote mediations, is it is relatively easy, if you are using the technology correctly, to draft a settlement agreement in an online mediation. Using the same screen share technology that you're using, Carlos, you can put up a Word document on the screen. The attorneys can collaborate and work about getting the language correct. And then that document can be emailed to people and they can sign it using DocuSign or Adobe Fill and Sign or whatever other technology that they have to get it electronically signed. And so I think that part works well, but again, it's something you have to be prepared for. So I think we have the tools necessary to make this work well, but I do think we have to think about the fact that following the requirements for the mediation requires a little bit more advanced planning, perhaps, in the online cases than it does in the in-person cases.
Robin, those are fascinating comments, and I bet someone is going to ask you to write an article for the Res Geste. Some of those things certainly seem obvious once you point them out, and maybe some of them are not as obvious, but and many of them seem to lie really in the attorney's hands to familiarize his client or her client with the technology, for example, or the need for a translator. And so those are, again, fascinating stories. John, what have you seen in your practice in terms of whether there's a need for a new rule, whether at the bar level or at the local level regarding remote mediation?
Yeah, thanks, Carlos. I think Robin hit all of the highlights, at least all of the highlights that I would have thought of, and then some. One thing I've noticed just anecdotally, and I don't know if I don't think it's an ethical issue, but I feel like it's easier for people to walk away in a virtual mediation. There's something about being in person and that kind of keeps people there talking longer. And at least my experience has been that I think it's easier for parties to, get up from the table and leave, so to speak, when it's done via video conference and or by phone. That's more of an observation than really an ethical suggestion. But at least according to what Robin said, though, the settlement rates have been good, if not better than before. So, maybe my experiences have been isolated.
Maybe it's just you, John.
Very, very well, maybe.
Okay, folks, we're coming on the last topic now, and it's about 10 till, so we got to speed this one up slightly. Remote trial ethics. Again, the idea is, do we need a change as a result of now we're doing things via video conference to try cases? Local Rule 4K, we already showed that, but I'll just scroll back to it real quick. This was trial conduct and courtroom decorum. Of course, there's nothing in there that specifically addresses remote conferences. Judges, what have you seen? What do you recommend?
Just the suggestions that we've already come up with, that would be worthwhile getting those to the Supreme Court. And Chief Judge McHugh seems to have the ear of the Chief Justice right now. So suggestions to Judge McHugh probably will make their way up to the Supreme Court.
Thank you, Judge Hayes. Judge Pallett, any additional thoughts on this one?
I think the application of what we spoke about in reference to the hearings and the submission of documents, that's really the crucial ones. Decorum, of course, it would be nice that if everyone just realized that they are in a courtroom when appearing remotely. But really, other than that, nothing really more in the trial arena to offer.
Just out of curiosity, you had mentioned that you had attorneys in tank tops and t-shirts and pajamas. Does the court warn them, or does the court say, don't do it again? Or how is your honor?
It's a tough call. Sometimes, when I see, if I have literally 80 people in front of me and there's an attorney in a t-shirt, and I don't know his attorney, I might say, oh, I didn't recognize you. That's kind of a hint. You don't look like an attorney. Maybe wear something appropriate. Sometimes I'm just so busy that I just don't have the time nor the effort to do it. So it just depends, and I don't want to embarrass anybody. I think that everyone should really know that a tank top to court is just not right, but.
Or at least exercise, look good in it?
Yeah. Oh,
Okay.
goodness gracious.
Robin, obviously you're acquainted very strongly with the remote trial litigation in the form of arbitrations. What are you seeing that you think there may be a need for in terms of a modification to either the state or the local ethics rules, if any?
The only thing that I can think of with regarding the ethics rules is the possible coaching of witnesses that can occur behind the scenes. And it seems to me that probably should be addressed directly, although I think we would think that everyone would know better. But sometimes if you don't address an issue, then it's sort of approved, tacitly approved. And I think that's something that should be addressed.
Okay, very good. John, what do you think?
Yeah, I think Robin said it best when he was talking about mediation, which I think the ethical framework is there. It's just a different application. One of the biggest ones that I've come across is with the rule of sequestration. Obviously witnesses, if the rule is invoked, are not supposed to be able to sit in on other witnesses' testimony, but you can never be too sure if, for example, you have a husband and a wife who are witnesses to the same case and who are both slated to testify as non-parties. Also, if you have a party who is able to sit in through all the testimony, who is in contact with a witness, either via text message or, something else, you as an attorney, I think, have an obligation to make sure that your client is not texting their witnesses on the side and saying, OMG, so-and-so just said this on the witness stand. I can't believe it. You need to say this in return or reply when it's your turn. So I think potentially some strengthening or evolution of the rule of sequestration type rules would be appropriate. But then all the other things that we touched on, decorum, provision of the evidence to the other side, and those types of things.
We have about 5 minutes left, and I've just sent out a chat message to someone who'd asked, but yes, please submit any questions. And I have a final question, food for thought. Would it be enough, panelists, would it be enough if we simply had a rule that specifically says these rules shall also apply to any remote proceedings? And of course, we'd have to define remote proceedings because we're lawyers.
I think it'd be a great start.
Yeah, that certainly sounds like a good idea. I guess one other thing to add before we leave too, the beauty of the mute button is so important too, if I can just remind everyone. And that might be something, because when you're entering a meeting and you're not on mute, you don't realize that there are sounds that come in, especially if you're participating in a conference or a hearing wherein there's people before you. So that mute button is really fabulous. Otherwise, the judge might mute you.
Any other questions? Again, please feel free to use the chat function at the bottom of your Zoom screen, and I'll come in. I can put my glasses on and actually read them. We've got 5 minutes left, so if you have any, send them quickly.
Carlos, I would say if there are questions or thoughts that people have, especially regarding mediation, I would be happy to hear that. Send me an email, give me a call, something. I'd be happy to discuss it. And it might be food for a future article for Res Gestae.
Okay. Yes, it looks like you've been called out publicly for that.
I think so.
Here's a question from a lawyer, and he and I have discussed this many times privately, not necessarily in this context, but just generally. You know, what is the line between professionalism, sharing documents, and hey, I've got some rebuttal and impeachment documents that I don't want to use until you show me that I need to use them? How does that work? Judges, Mr. Miller, Doyle, thoughts?
Arguably, you don't have to until the other comes out. I mean, arguably, you don't have to disclose them ahead of time.
Yeah.
Agreed.
Yeah, I mean, I think the rule is fairly clear. You know, you always run the risk, though, if you decide not to disclose and then you try to use it, that you may not be allowed to, because it may not purely be for impeachment purposes or something along those lines. So if it's something that you absolutely think you have to get in, you know, I always tend to err on the side of providing it or producing it ahead of time, rather than crossing my fingers that it's going to be admitted as purely impeachment.
So here's an issue that I could see coming up, is that we have a rule that says, hypothetically, we have a rule that says you must provide your deposition exhibits no less than 24 hours before the start of a deposition. And I've got one really juicy one that I'm not going to use, but it's not really impeachment or rebuttal because it's a deposition, right? It's a different context. But I might use it depending on what you say. So if I hold it back, but then I need to ask about it. I mean, I have an ethical obligation to represent my client, so I feel I have to ask about it. Then what does the other lawyer do? Does the other lawyer now have a bar grievance, or is it merely a motion? Is it merely an objection on the record to be settled later at a motion in limine? I don't know the answer to that question. I think the latter is probably the right answer, but I just don't know.
Hey, Carlos, can I ask a question rather than typing it out? Because I sent the last one in and it kind of goes to John Miller, but I'm also interested in what the judges think. You know, one of the tools as trial litigators we have is what we get as work product ourselves. And, you know, the ability to have a document that I obtained through work product at a deposition and not have to share it ahead of time so that John Miller can prepare his client for an answer that would be very different than if I just shared it with them, we really need to be concerned about, because I think you could lose, you know, the effectiveness of a really good lawyer being able to do his own homework and get some document and then say, well, you didn't share the document with me ahead of time. I don't think that's a path we want to go down, because it really hampers somebody from doing their own work product. Or, you know, if I have to send something ahead of time to John Miller, he's going to know where I'm going to go and he's going to prepare his client, which defeats the purpose of locking somebody in a deposition.
Or you could send 1,000 documents and only ask questions on 3 and just bury it. Not that I would do that.
And Mr.
No,
Zabo,
but I think Doug brings up a good point. I mean, there are definitely circumstances in which, for strategic purposes, and it wouldn't be an ethical violation under the current rules to hold something back at a deposition. And so I think if we're going to recraft or, you know, rewrite the rules of ethics to deal with the virtual world that we now live in, I think we've got to be cognizant of those types of things so that we don't, you know, foreclose the ability to zealously litigate for our clients by, you know, holding stuff back that's currently ethically fine to hold back.
I agree with that. Obviously, you have an ethical obligation to your client and you have a professional obligation to the bar. And you just got to make your calls as you go as best as you can. If there's an objection that you see, that you make your objection, or and then the attorney can state the reason why they didn't on the record. Share the document beforehand.
Folks, any other questions? We're at 1 o'clock.
I want to thank you all for being patient with us as we rework all of our dockets to accommodate the coronavirus. And it's been a real challenge, and we appreciate everyone kind of digging into and adapting and being flexible. We really appreciate it. And it makes our jobs much easier. And thank you.
George, did you want to say something?
I just wanted to express my appreciation to the panelists for a great program. Thank you very much.
You're welcome.
Well, folks, I echo George's comments. Thank you to our fine panelists, Judge Hayes, Judge Pallett, Robin Doyle, and John Miller. Great comments, great observations, great participation from the audience, and questions as well. And I hope everyone found this discussion useful. It may be that there is a call, I have no idea, but there may be a call to draft some additions or supplements to the local rules. And so I think this is probably an important starting ground. The Lee County Bar should be emailing you the CLE credit code. And if you don't get that, feel free to email me or Lbaugh. But you should be getting that, I would think, within the next week or so. Thanks again.
Thank you.
Have a great
Thank you.
Thank you. Good seeing you all.
Thanks, Carlos.